Great, so I think we're going to go ahead and get started. So welcome everyone. I am Maureen Levy, and along with Neil Siegel, I am the director of our program in public law here at Duke, and it's so nice to see so many of you all here. We are honored today to have such a distinguished panel of chief justices, judges, and court administrators to discuss an incredibly important and timely set of topics: courts, fees, fines, and bail. So we have Mary McQueen, who is the president of the National Center for State Courts, and David Levy, our own beloved former dean, and now the director of our Bolch Judicial Institute, moderating a panel discussion for you all today. David, I will hand it off to you.
Thank you, Professor Levy. So we have a great group of people up here, really from my point of view, the heroes of our judicial system, the leaders of our state courts, which is where so much of the action is right now. Justice Scott Bales has just left being the Chief Justice of the state of Arizona. He's going to become the director of ILES, which is a law reform institute at the University of Denver. And sitting next to him is Chief Justice Judith Nakamura from New Mexico. And seated right next to me is Mary McQueen, who you just heard about. She is president of the National Center for State Courts and one of our leading law reformers in the system. And seated next to me is Martin Hoshino, who is the administrative director of the California Judicial Council, which is a very big job. It's a gigantic court system, dwarfs every other court system. Seated next to him is Judge Douglas Beach, who had the honor of being the judge who ultimately was in charge of what you may recognize as one of the hot spots in America, Ferguson, Missouri. And he has a very interesting story to tell about that. And seated next to him is our beloved former Chief Justice, Mark Martin, now the dean at Regents, right? Did I say the School of Law in Virginia Beach, which is probably being pummeled right now, but we hope not. Anyway, Mark is going to race back there and blow back at the wind. And then on the phone, I believe, is Stuart Rabner, who is the Chief Justice of the state of New Jersey, and probably no one more responsible for bail reform in New Jersey than Chief Justice Rabner. Are you there, Stuart?
I am. Thank you.
Oh, gosh, you're coming in loud and clear. Oh, really? Yeah. You have a kind of authority in your disembodied state that the rest of us, mere mortals, don't actually have. So actually, while you're coming in so loud and clear, maybe we could just start with you. And so we have been meeting all today, and we began last night, to talk among ourselves, judges and scholars, about this vexatious problem of fees, fines, and bail, excessive bail, undue fees and fines, and the ways in which these sometimes well-intentioned impositions have such negative effects on, particularly on poor people, devastating effects, and it creates what we've been calling the destitution pipeline. So in law school, you study cases and doctrine primarily. This is what we are studying is the way court systems actually operate, and this is a very data-intensive kind of inquiry. Of course, there are a huge number of very important normative issues that drive this. So, Stuart, why don't we start with you? How do you see the problem? What have you been doing? And in round one, let's try to keep it to 3 minutes if we can.
Sure. And what I would say to you about the volume problem, just do what my kids do at home. Turn down the volume. That way you don't have to listen to me. I see this done with success on a regular basis. We have the same dichotomy. We look at cases. We address them. We do our best to study the record and figure out the right answer in a particular case. And then we get involved in initiatives like bail reform and municipal court reform, where we're trying to improve the quality of justice in the state. And that's what we've done there. With the time limit, I'll just speak briefly about the bail reform effort that's been going on for now 6 years. So I won't get that far in 3 minutes, and that's okay. But what we saw, which so many other states have seen as well, is too many poor defendants sitting in jail for weeks or months on end because they couldn't afford to make even modest amounts of bail. And these were not individuals who presented a risk of danger or flight, the reasons that pretrial release decisions are being made. And then others who did present those levels of risk could get out because the Constitution guaranteed a right to bail, and if they had money, they were able to be released. So we set out after a study was done that showed how bad the problem was in our state. It's easy sometimes to lose sight if you're looking at what's happening elsewhere, but if it's in your own backyard and 12% of the pretrial jail population is there because they can't post relatively small amounts of bail, you know there's a problem. And we created a large committee with stakeholders from across the spectrum, advocates, practitioners, judges, prosecutors, defense counsel, the ACLU, and others, to work together and come up with suggestions about moving to a risk-based system where people would be released and monitored, and those who presented the highest level of risk could be detained. And it ended up being adopted as law, and the voters approved the constitutional amendment. And for the past 2 years, we've been working with this system to try to ensure that our system of justice overall is a better and a fairer one. And what we're seeing is very, very little use of monetary bail anymore. It's still part of our statute. 1 in 1,000 cases on average is bail imposed. And instead, most of our defendants are being released, well over a majority, closer to about 75, 80% if you look just at those who've been arrested, and an even higher percentage if you're looking at the whole universe, are released with no conditions or some conditions, and the highest risk are being detained. And we've closely monitored the data. People are still showing up in court with the supervision, with the reminders. People are not committing crimes at a rate that is significantly higher than what had been going on before. We have a lot of work to do in this area with respect to domestic violence and tweaking the risk assessment tool and continuing to hear criticism from community groups. But it's been a worthwhile journey so far and an important one. Thank you.
Thank you. Scott, from your Arizona perspective?
Well, I'm pleased to be here at Duke Law School, and before I turn to the Arizona perspective, I just want to put this in a broader context. Any day in the United States, about 2.2 million people are incarcerated. Another 4.4 million people are under some kind of penal supervision, probation, parole, community supervision. And those facts relate to fines, fees, and bail, because fines, fees, and bail not only can contribute to cycles of poverty, they can contribute to cycles of criminalization. Of the 2.2 million people incarcerated, about 750,000 are in jails, and something like half of them are people that haven't yet been convicted. They're awaiting the disposition of their charges. And we know from studies in Arizona and from national studies that if you unnecessarily hold a person in jail, even for a day, it increases the likelihood that they're going to commit a crime once they're ultimately released. So if you care about fairness, if you care about public safety, if you care about saving public money, you want to reduce the unnecessary incarceration of people, and that's tied into fines, fees, and bail. So what we've done in Arizona through a series of rulemaking, administrative orders, and some legislative changes is we've directed the judges in making the determination whether a person will be detained or not pending the disposition of their case to identify the least onerous conditions that are consistent with ensuring their appearance and preserving public safety, and requiring that they not impose bail unless there's no effective alternative. So the challenge that we're facing in Arizona is having adopted those changes in terms of the rules, changing the culture among judges who for a long time had relied on things like bond schedules, and when a person appeared before them for their initial appearance, they would simply look and it'd be like going to a restaurant, and the menu said that for this offense of disturbing the peace, the price was $200 if you want to get out of jail, and you'd languish if you couldn't come up with it. But it's very important that we implement that change. As I said, if you care about fairness, if you care about public safety, if you care about saving public money, we shouldn't be holding people unnecessarily in jail just because they can't come up with a bond.
New Mexico followed New Jersey, although I'm not speaking with the voice of authority today. But we, in addition to what Justice Bales said about folks getting out of jail and committing a new crime, they're losing their jobs. Every day they sit in jail, employers aren't waiting. And we found also that folks who went into jail without a drug problem came out with one. Their first experience was happening because we all know there's a proliferation of, there's so many drugs in jail. So what we did as well is in New Mexico, our Constitution required that everyone be bailable. And judges were interpreting that to mean, great, you're dangerous, I'm going to set $1 million bond, go bail yourself out. Because our Constitution didn't allow dangerous people to be held without bond. So in 2016, 87% of our voters approved a judge's ability to hold the truly dangerous in jail, and we're using a risk assessment tool to determine who those folks are. And everyone else has a right to bond, and what happened, a right to bail, and no one any longer in New Mexico can be held in jail because of their financial inability to pay to get out. If you're truly a danger, you're being held. If you're a flight risk, the bail can be set. And what ended up happening, and judges have to articulate in writing why they're setting bail for someone. The presumption is released on your own recognizance now in New Mexico. So we went from 33% of our jail population was being held on bond prior to the constitutional amendment. That has now dropped to 4.2%. And those folks are, that 4.2%, we're looking individually now, who are those people? I believe it's going to prove to be the truly homeless, the people that you could put $1 and they're not going to be able to show up. So the detention rate has dropped. Crime, this is what's really interesting because everyone was worried all these people are getting out now on ROR. In fact, crime has been plummeting in our jurisdictions. Now that we're using risk assessment tools, we're able to hold the truly dangerous and release the poor back into the communities before they need to appear in court.
Thank you.
Thank you. I'm going to give you the California experience, but it might not be all that different from all other states. And in 3 minutes, I'm going to try and unpack and give you the short version of a 30-year history. So in California, we've set up a funding system for any myriad of 200 to 300 programs, state and local levels that are being funded off of the fine, fee, and assessment, surcharge, forfeiture system, whatever you want to call it. This is a phenomenon that occurred over the course of those 20, 30 years. It starts with, at least in this subject, in the 90s or so, there was a set of base fines for every infraction that occurred. Then after that, there's a series of what we refer to as add-ons, and those are all of the fines and fees that I suggested to you previously. These get piled on over the course of time such that you now have a revenue system that is generating about $2 billion a year in the system. This is instead of the traditional methods that you fund government services, which is usually in the form of an array of taxes and other kinds of assessments that people are used to. Now, over the course of time then, at the same time we're collecting this money in a 10-year period and window in time, we can now see after all of these well-intentioned retailed add-ons to fund brain injury, to fund medical support, to fund DNA identification, you now have a debt problem in California where 10 years ago it was $5 billion of what we called uncollectible delinquent debt, and is now $10 billion. So you're still generating $2 billion, but you've got a problem where the amount of debt is rising. Now, why is that happening? It's because we've crossed the threshold of really what's affordable potentially for the residents or the people who are caught in this particular machinery and cycle. Now, the challenge is how do you go about unwinding all of that at this time? And that's kind of how it works. You get a traffic ticket, I'll illustrate it, because it could be you or someone you know that this happens to. You get a traffic ticket, let's say it's speeding. The base fine in 1990 is set at $35. When it arrives in your home, it's $238. Running a red light, $35. Now it arrives in your mailbox, it's $490. It's because of all of the add-ons. Now, you have to appear in court. If you fail to appear in court, we then add on a $300 civil assessment. You miss it again, we add another $300 civil assessment. Then you miss it again, and then here comes a bench warrant for your arrest. And then during that arrest, other things potentially happen, and that's how it becomes the destitution pipeline, even though it started as this macro public policy on how it is you'll actually fund government services. So in California, our attempt has been to do a number of things, which is one, we've done 2 amnesty programs in an attempt to forgive debt, but more importantly, put people on payment plans. And if you go on these payment plans, we restore your driver's license, because driver's license suspension becomes another part of that, which is another part of bad public policy, because we know Americans generally drive to work. The ability to work is the ability to get paid in order to pay off my fine and my fee and my infraction. So I think you can see the point. The other thing we're doing in California is right now working on ability to pay. Because this built up and making it part of the decision, it built up over those 20, 30 years, one piece of law, one piece of legislation at a time. It's hard to unwind that in a wholesale fashion because you're going to try and solve a $2 billion revenue problem. And so our attempt is to bring ability to pay as a part of the judicial decision-making, where we can right-size now what is actually affordable for folks with the amount that they actually owe. So you can, if you owe $500, but we determine that you can only pay $250, that becomes the amount. If it needs to be a payment plan, put you on the payment plan. It is our best attempt at this stage in order to deal with the proportionality problem and restore fairness in a system that didn't intend to end up in this wholesale manner, but that has in fact happened. While we hope one day we will get to a bigger discussion about how will you actually address the tax revenue structures for government services, basically that was formed in the 1950s, and how will you make that work for a 21st century economy? And so I know that's a high-level piece of it, but this is how it gets down to the ground and how it actually results in a pipeline to destitution.
So a lot of this issue came to light when there was rioting in Ferguson, Missouri, and the Department of Justice issued a report that essentially the courts had lost the confidence of the minority community because it was viewed as a tax collector and as a very unfair one. You've been dealing with this, Doug.
So I was lucky enough to be elected as the presiding judge for St. Louis County on a Wednesday, and on Friday, the Supreme Court decided that I would now, all presiding judges would be responsible for the municipal divisions, which are part of the court system in your circuit. I had 89 cities to be added, including one of those was Ferguson. So it's an administrative issue that, because these courts, as well intended as they may have been, had never been supervised. They ran pretty much themselves. We found that the clerks ran most of the courts because the judges for those kind of courts, at least in Missouri, which I'll call limited jurisdiction courts, are called different things around the country. They were only part-time. They came in 3 or 4 hours and did a docket. So everything that you've just heard is very true in a little bit higher level than my experience had been, which was boots on the ground. I was supposed to go in there and I'm supposed to implement some of these changes which were required. In fact, we came up with the Supreme Court with minimum operating standards, which were really not new. They were just codified in a way so we could see where they were. And then I was trying to get each judge to run their court like that. And most of the time the judges said, well, you need to ask the clerk. I have no idea what you're talking about there. And in Ferguson, there literally is an email that the Justice Department has where the mayor said to the chief of police, where our revenues are down, now we're talking 2008, 2009, when we're having a downturn in the economy, can you write tickets and get us up by 10%? And his response in writing was, I think we can do better than that. Well, that, of course, applies to the court system. And the court and the judge, who I've known personally for years, I was surprised to hear the kind of dollars and cents that were attached. There's one city right next to Ferguson. They have just over 2,000 people, and in 2014, they brought in $2.2 million on traffic tickets. So that's like everybody getting 5 tickets in town in order to get it done. And then you wouldn't just get 1 ticket. The police department, in conjunction with everybody else, would write you 6 tickets when you get pulled over. You didn't just get 1. And don't say anything back to the police officer, because then you're going to get arrested. And then what happened when you started having fines which people couldn't pay, when you have a $500 fine and you make $1,347 a month in gross pay in Missouri as a minimum wage, $500 is not going to happen. So what would they do? Well, they didn't come to court. And when they failed to appear in court, then the judge would issue a warrant for their arrest initially. There was no, hey, did you miss your court date? Did you forget? We didn't send text messages reminding you at that time. You got another failure to appear. That would be $300. And then one of the other things that we were having in terms of minimum operating standards was there wasn't a judge. The judge, if arrested, it's only the judge can let you out or set bond or determine whether you're going to stay. Well, if the judge only worked on Tuesdays and you got picked up on Thursday, you stayed until next Tuesday. Well, that, as you heard earlier, 1 day in jail is bad enough. When you have a week in jail for no reason because you violated a traffic ticket and you can't pay or you didn't show up in court, we did not address those things. We are addressing them now. But it's very difficult. It is a cultural change. Since England in the 1200s, we've been dealing with dollars and cents as a way to bring the public into following the law. And somewhere we may have gotten lost with that, but the guy who's a professional football player, $500 to him is different than to somebody else. Something I've done, the statistics is not exactly right, but about 4 out of 7 people in the country could not come up with they don't have $500 of spendable income for a sudden thing like a $500 bail. So that just kind of could snowball, because I was dealing with 70% of the citizens in this country, their experience in the judicial system is in these small courts. And so those then led to that goes on your record. You have a failure to appear. Now you get picked up for something in the state court. In the state court, you can't get out of jail because you have a warrant for your arrest for failure to appear in some small municipality. So we had in Missouri, and in St. Louis County in particular, we had 62% over a 7-year period of the people that were confined in our jail were there because they were there for pretrial confinement or a probation violation. And we set up a committee to look at why are these people, anybody held for more than 100 days? It was time after time after time. Their bond, and maybe it said at $1,000, was now down to $200. They cannot raise $200 to get out of jail. They're only there because they couldn't come up with that money. In one situation, our judges started saying, well, you can get out with an ankle bracelet, but we didn't have any money, so we'd let them out. Condition was you have to go over and get an ankle bracelet. That was $300. You violated your condition of release, so you go back to jail. And so there's this cycle that just continues because they can't get out of that cycle. So it's a very large problem. It's a very large effort. There's a lot of good things being sent at it. But when you get right down to it, what I have found in my 89 courts that I was responsible for, it's the judge and the culture that judge establishes as to following the rules of the law and taking into consideration somebody's ability to pay. If you have 200 people on your docket tonight and you started at 6, if you want to get home before midnight, you're not going to be spending a lot of time. Lastly, we found what are alternative ways, community service, doing something else. We have been offering community service. We cannot order it. We offer it. Very seldom does anyone want to take, judge, I think I can pay that fine. Can I pay that fine over time? Well, there today may be at $20 a month, but next week they may not have that job. 2 months later, they may not. And we need then to follow back up with it and say, what is your ability to pay? So these are efforts which are ongoing in every state. Ferguson was the heart of that. Not only was I put in charge of that, I was the lucky judge. We have a judge on duty 24 hours a day that was on duty when the riots occurred. So I had firsthand accounts of what really happened and how it affected people that night in their real lives. And it's a very telling but very meaningful thing when you start seeing people whose lives are unraveled for doing silly little things and they just get caught up in the cycle.
Good afternoon. Delighted to be with you, and also thank you for spending your lunch with us on this panel. In North Carolina, I want to kind of break this down into good news and bad news. So the good news is North Carolina has what's called a uniform court system. So that means when a fine or a fee is imposed, that the proceeds go right to the general fund for the state. So you don't have the same perverse incentives that can arise in a Ferguson situation or a municipal court system where oftentimes fines and fees were used for employee bonuses or new furniture or what the case may be at that local courthouse. So that's a good thing. Secondly, over the last few years, we were very successful in moving forward with juvenile justice reform. And so 16 and 17-year-olds are no longer automatically tried in adult court for 97% of the type of offenses that teenage defendants were confronting. And so that was a huge progressive reform for us in this state. And last but not least, we've also made great progress on expunction reform. I don't think it's a mystery to anybody in here that the overwhelming majority of criminal defendants that have active confinement will be released. And so rehabilitation always has to be a part of the equation. Because if not, you're releasing someone, and the Chief Justice alluded to earlier, who may just have simply learned new skills in prison that are really not the type of skills that we were hoping that they would learn. Addiction to drugs, a young offender interacting with a more senior offender who has had a lot of experience committing crimes. So in order to bring people back on the street in an era of online, pervasive background checks, you have to have a mechanism for breaking that cycle and allowing defendants to fully participate in the marketplace again. So what's the bad news? Well, this state is ground zero for major problems with fines and fees, and we have to acknowledge that. One of the problems, and I'll zero right in on driver's license revocations, we have 1.2 million citizens who do not currently have a valid license. It's either in a state of suspension or revocation for failure to comply with court obligations or failure to appear. I want you to think about that. 1 out of 7 North Carolinians unable to legally drive a car. So what happens? Well, more often than not, they have to drive a car, right? You got to get to work. We don't have readily available mass transit across the state. Matter of fact, we don't have readily available mass transit in many parts of the state, right? So you have to have the ability to get to work, to be able to support yourself, at least if the goal is to keep you in the legitimate side of the marketplace, correct? So all too often, we are forcing drivers to operate cars illegally, or if they follow the law, they lose their job, or even worse, engage in criminality. So we need to look at several areas to make the system work better for people who find themselves generally in the criminal justice system for a relatively minor matter. This could be something as basic as speeding, right? Parking in the wrong place. And the aggregation of penalties, as Martin shared, where somebody does not seasonably respond to the financial penalty, and it grows over time because of certain ways in which the system is operated. So in closing, we generally have a system here in North Carolina where you have a failure to not pay, where there will be a notification sent to DMV and a mandatory revocation without any opportunity for the driver to contest that in a judicial forum. So 2 reforms that are very much needed here. Number 1 is an individualized determination of ability to pay when you're still in criminal court for an infraction, misdemeanor. And then secondly, instead of an automatic revocation, where DMV just sends you a letter and says your license has been revoked, we rewrite that letter. And it says you're in default, you have an opportunity to appear and explain why you're in default, and then consider a number of options. Are they able to pay? Will installments work? And work in a practical way to make sure that we're not punishing people when they are utterly incapable of paying.
So I wouldn't have asked you this last year when you were still Chief Justice, but most of what we're talking about is the product of state legislation, and it's the legislature that is the ultimate authority here. What's it like working with the state legislature on these problems when you say the same? I'm sure you said the same things to many of them that you just said here today, and yet here we are.
Well, first, let me admit my failure. In 2016, I made a public plea that we would have more individualized discretion by our trial judges to waive or remit penalties. Instead, the opposite happened. And Martin alluded to it. In California, you have $1.5 to $2 billion in revenue. Well, you have stakeholders who rely on the revenue, and the same here. So you don't really want to call government actors vested interest, right? But you do have people that are typically used to having that revenue. So we've kind of gone in the wrong direction on this. And I think we need a fundamental reexamination, which I can freely ask for now that I'm no longer Chief Justice, to what is the goal here? In other words, if the goal is to make sure we don't have debtors' prisons, right? I mean, last time I checked, that was supposed to be unlawful since the founding of the country. But yet we see shades of gray how it's crept back in. Because the reality is the inability to post a bond, if you don't have that individualized assessment, it could be akin to denial of bond in a practical way. And so what I would tell the legislatures is the same data metrics that we did on juvenile justice reform and also on expunction reform. And that is that reforming the fines and fees process, number one, is going to remove a lot of unnecessary clerk entries. Think about how many entries are made by clerks of court around the state and all the paperwork, and we know in advance that none of it will ever be collected. It's just form over substance. So that's point one. Point two, as I indicated this morning during our discussions, we really need to come up with economic impact information so we can go to the General Assembly and say, look, we're not talking about being easy on people who aren't driving well. I mean, we can have safe driving training. We can use GPS technology to make sure that a driver is just driving to work and back and not the bar every day. And third, we can use other forms of community service in lieu of financial obligations to really meet critical needs in the community and in a situation where we know the money's not going to be collected anyway. So I think that's the approach that I would use with the General Assembly.
So I think for a lot of you, state courts may be an unexplainable animal, but about 97% of all cases in this country are filed in the state courts. So as you go through your law studies, just kind of keep that in mind. But state courts are not like, and the chief justices, although they are the chief judicial officer in the state, it doesn't work like a pyramid, like your Microsoft, and you can tell everyone what to do. I like to define it as a constellation, where you have all these brilliant stars that occasionally align into patterns, but not at all like a pyramid. So I wanted the Chief Justices to comment because within the three-branch of government system that we work, and Dean Martin has talked somewhat about legislature and, how we can, but within the judicial branch, what can we do as far as judicial education? And I'll give you an example. The Conference of Chief Justices just finished, well, not really finished. Tina Vajanis here is the chief counsel for the Conference of Chief Justices Task Force on Fines and Fees. And one of the things they looked at was when you have a traffic ticket and come to court, or you don't come to court and you're charged with failure to appear, that's a misdemeanor, if in fact the traffic offense has been decriminalized in some states. And that can carry jail time, right? So everybody knows about Gideon and, your right to counsel if you can't pay. And so a big issue became about when do you have to tell defendants that they have a right to counsel? Do we have to put it on the back of the traffic ticket? Because when you show up in court to say that you can't pay, or on a failure to appear, the first time you're advised that you have a right to counsel is when you're in the courtroom. So believe it or not, there are a lot of part-time and there's still a lot of non-attorney judges in this country that have no understanding of Gideon or Bearden or any of the cases that come along. So I was going to ask the chiefs to give us some examples of what we can do or what is being done within the judicial system to bring those trial court judges that see these cases every day. How do we make sure that they embrace those recommendations?
Judicial education, judicial education, judicial education. And in New Mexico, judicial education is funded by fees on tickets. And by the way, about half of our judges are non-lawyer judges, not all of them under the state system. Half of them are in the municipalities. And although the Supreme Court's responsible for their discipline, that's about it. They're paid for, they're funded, they're operated day to day by the local municipality. So if you get stopped for a traffic ticket in New Mexico, you get $3 added on to help fund judicial education. Well, traffic tickets dropped pretty significantly, in part because our biggest police department was under DOJ investigation. Policemen started getting afraid of stopping people, and traffic tickets over the last 8-10 years or so has just really declined. So our judicial education budget for the whole state, including the municipal judges who we are responsible for educating, was about $1.5 million. And over the past several years, it's dropped to about $800,000. So rather than going in the direction of educating more about this destitution pipeline, we've been cutting back on judicial education until we did go to the legislature last year and got down on our knees and begged, and they're starting to supplement that fund now with some general fund money. But we need to educate our judges that people who do not pay, it's not an affront to their authority, that there are other factors such as poverty that's driving inability to pay. And so to me, I do agree, one of the most important things we do is educate our judges, but not on a fee-based system.
And Mary, I'm going to divert a little bit from the way you posed the question, because I think the educational role for state courts, particularly for Supreme Courts, goes beyond just the judicial branch. I think in those states where you've seen successful reforms, it's often in part been a consequence of leadership within the courts, but leadership that helped enlist the support of the legislature and the executive branches. Because if you explain to people, look, the way this process can work is someone can get cited for a traffic violation. They fail to show up. Their license is suspended. They then get stopped for driving with a suspended license. And in some states, that could result in their arrest on the spot and the impoundment of their vehicle. So you've just created basically a self-perpetuating cycle of poverty, if not criminalization, that many people can't get out of, because by that point, the fines have mounted to a level that are unpayable. It's easy to make the case to other branches of government that kind of process just makes no sense at all. And you just have to explain that whether your priorities are public safety, fiscal responsibility, basic fairness, you need to change the system. Oliver Wendell Holmes once said that law is civilized only to the extent that it's conscious of what it's doing. And with respect to fines, fees, and bail, for decades, we weren't really paying attention to what we were doing. And I think it's critical that courts be part of that education process, but not just with respect to judges.
Can I ask Martin just one quick question? So a lot of times what the Judicial Council in California does is develop tools for judges or for the courts to use in this. And so one of the things that has been utilized, and I know that California was leading that, is income calculators. And so you might talk about, rather than there just being a flat fee that everybody pays the same thing, maybe we should be looking at proportionality in some way.
Yeah, thanks, Mary. I flew over it very quickly in my earlier 3 minutes, but that is the project that's underway. We're kind of working with your national center and others on it, hoping to scale it statewide and make it available to others, but it does attempt to restore proportionality. Right now, in the early stage, we generally are allowing folks to self-certify what their levels are, but we are asking them really just to take pictures of the public benefit assistance that they're getting and the like, while we build the income calculator from the other databases that you would start to link to. There's the Department of Social Services. We can get information that we see we were modeling off of the expansion of healthcare in America. So there are ways to get there, because the key is not only does it have to be fair and proportional, it has to be operational. Because of the volume that we are talking about, if we are asking judicial officers to do this, they have to have a tool and a calculator that is rapid, valid, and that is reliable so that they can have confidence in it. Because part of getting to the individualized assessment is when you go and do these things, you can't create really more time for a system that is really always out of time, and the volume that has to get processed. So we're in the early stages of just allowing people to do basic ways to prove up where they are, and it's mostly based on whether or not you're on public assistance, what your benefits are, while we build out the infrastructure to link things together, to have something that's a little bit more robust and a little bit more reliable. But we're not going to let the perfect be the enemy of the good.
So, Stuart, you had such tremendous success in New Jersey in radically changing the bail law, and I'm wondering if you could talk about how you worked with the legislature, and also, I believe you were funded in large part by a private foundation, and I think that's interesting as well.
So we brought the legislature and the governor's office into the conversation right at the beginning, and we've done this with all of the important public policy type committees we've had, whether it's foreclosure or mental health, or municipal court. We had legislative leaders or their key aides as members of the committee, and the same for the governor's office. And what that did, following up on the earlier comments, is it helped educate people from the start and created allies who in turn wanted to go out and sponsor some of this and seek to advance the issue. We broadened the conversation, which helped us with the legislature and with other groups. For example, you had some people who cared passionately that no drug kingpin should be allowed out, even if they had access to $500,000, because they might intimidate witnesses. You had people who cared passionately that poor people not sit in jail for all the reasons we've talked about. And then you had government officials and others, county administrators, who said, why are we spending $100 a night for weeks on end for somebody who can't make $200 bail? And it was by broadening the conversation that we were able to make advances and propose a package of recommendations. I also have to say we got lucky. We had a governor who cared strongly about detention. We had legislators who cared passionately about other issues, and they thought of our forum, the court, as sort of a neutral place where we could work together, and it didn't have some of the perhaps competitive aspects that might otherwise have existed. And we overwhelm them with information on a regular basis about the data and the results to educate and to teach, as so many have stressed, is critical. And the same for our judges. They want to do the right thing. It helps to give them the tools.
Thank you. Why don't we open it up? Who has a question for anybody here? Yes.
I've only seen it when you have a showing of potential mental health issues with the person coming into the system. We have an approach here that when you are admitted to a jail, I mean, there is a doctor that comes in and makes, sometimes it's somewhat cursory, but at least an examination to make sure that the defendant is not a threat to himself. I think you make a really good point. Now, what we've done pretty good at, I think, across the board is trying to separate youthful offenders the best we can from recidivists, but with, very much an imperfect way. I mean, if you're a young offender and you commit a violent crime, it won't be too long before you're probably housed with others who have committed violent crimes. It will be in a cohort of older defendants, typically, that have done a lot of horrific crimes. But at least here, I'm not aware that that's been, of course, we're at the embryonic stage, and we have several local justice systems that are beta testing these systems, but it has not been adopted statewide.
I would say that the biggest change that's taken place, I think, in the legal and the court system over the last 50 years is moving from concentrating on cases to concentrating on people, and actually using kind of a triage approach when somebody comes into the court system. So there's a lot of attempts to look at ability to pay, to look at some of those issues about the individual, not just about the severity of the crime that was committed. Those are taken into factors. So I think some of these risk assessment tools are being used for that, for judges. I'll give an example. Somebody will come in and say, well, I really can't pay, and somebody will look and say, well, where'd you get those Nike tennis shoes? Or, that's not okay. Justice really is supposed to be blind to those types of issues. And so I don't know if that gets too directly, but yes, there are efforts in almost every state to look more at the individuals. That's why you see this emphasis on like drug courts or problem-solving courts or veterans courts and mental health courts, is because we've learned over time that this is about people. It's not just about cases. And how many cases did we dispose of, or how fast did we dispose of them? So I would say that's been one of the biggest changes that I've seen. And it is based on looking at the individual.
Well, and I think you raise a good point in that the assessment tools that have been developed, they're focusing on the risk that the defendant either does not appear or commits another, or is arrested for another crime on release. But the tools, and it's carefully chosen word, tool, they don't answer the question whether a person is held or not. That's still a decision for the judge, and it gets to the last point that I want to make, and that is it makes it all the more important that those individuals have access to counsel who can advocate on their behalf and explain why, perhaps for reasons not reflected in the tool, there isn't really a risk that they'll fail to show up, because in fact, they have a job, they have a family, they have support in the community. So that's the way that we've effectively are getting at those personal side characteristics of the defendant that might complement the information that comes from the tool, but it puts a premium on their having effective representation.
Can I just add, embedded in the tool, it's not just low, medium, and high. That's the derivative outcome. Behind that is information about your criminogenic needs or past or background or your mental health issues. Do you have housing? Are you employed? Is there anger management issues? It depends on the type of tool, but some of them will go that far, that deep, and it becomes important to a judicial officer, because if they're going to make a decision on release, whether it's OR, whether there's some conditions or supervision or monitoring, they might tie drug treatment to it. They might tie other aspects to it. So some of that's behind that, and it's available to the officer if they choose to dig for it. I hope that answers your question.
But as we go in that direction towards more individualization, there's the other part of that is if you're the judge making the decision and you don't have services to provide this person, they have mental health issues, they have drug issues, they're homeless, and you're prepared to let them out on their personal recognizance or with these minor requirements, but you're letting this person back out into a world in which they haven't functioned perhaps when they got there. And so unless the social services and the rest of the government is bringing the services together, then the judge, I've had conversations. I'm keeping him here to protect him. He has nowhere to go. He's not going to necessarily commit another crime, but he might be, and he doesn't quite fit our criteria for harming himself. So there, you begin to get all kinds of issues which go with doing the correct thing that's going to help that society and that individual when they go back out into the get out of a jail situation or out on bond. But what do you do when your parents say, I'm done with him. I'm not coming to pick him up. I'm not going to give you $100 for him. You can keep him for as long as you want, and they go out onto the street.
Yeah.
There's
So one of the questions is in regards to this focus on the individual certain statistical biases against social economics or against people of different races that might be overrepresented within the prison system. How do you overcome that? And are you at a risk of, while trying to ameliorate the issue, actually create a larger problem using these tools?
I would say judicial discretion has to be used as part of that. The tool can't make the decision alone. It's just to provide additional information. It's not the final decision.
It's a great question, and it's a one to ask, and I think the systems are all struggling with it right now with risk assessment tools, because one of the central elements is prior convictions or prior arrests. And if you believe that the system, criminal justice system, is already embedded and it's institutionalized levels of racism, then that's how it gets derivative into the tool. But being able to know that and to say that, and back to education and training, making sure judicial officers are aware of both the strengths of the tools, but also all the limitations that you just asked about those tools need to be in front of the judicial officer and the judge when they're making their decision related to that. And at the same time, as the system embarks on this, I know in California, we are setting up the data sets. Is it that black males come out high risk more often than white males on the same charge, and where and why? And if you go into it, you can actually test and plumb for the thesis and, again, make adjustments as you go forward. But there's a healthy debate, that's probably the best way to put it, a very robust and raucous debate going on in criminal justice and the court system about risk assessment tools, based on your question.
Well, and it's important to recognize that there's not just one risk assessment tool out there. Some have been, I think, appropriately criticized for explicitly building in socioeconomic factors and, in some instances, gender and race. Others do not. Others keep that out. Another thing, though, to keep in mind is anytime you're going to have preventative detention, that is, anytime you're going to hold people pending the disposition of their charges, you're going to have some kind of risk assessment. It might be a judge looking at somebody and sizing up whether they think they're going to behave themselves if they're released or not. What a risk assessment tool does, if it's done properly, is it gives you a tool that is going to be uniform, is going to be potentially validated, will be transparent if you're very open about what the factors are and how the calculations are made. And it gives you the opportunity of being fairer in those respects by tamping down the opportunities for an individual decision maker to exercise biases, whether implicit or explicit. But you're right, those are fair concerns that we have to be conscious about as we're both developing the tools and assessing how they're actually working.
Stuart, do you want to address this?
So I didn't hear the question, did it? If you could just summarize it for me. I agree with a lot of the answers, and I would like to add.
The question is whether these risk assessment tools incorporate biases.
That's kind of what I thought. It's something that we need to continue to watch closely, and we do. And I'll tell you that just look at the numbers that I'll share with you from our experience these 2 years. The jail population in our state is now down, the pretrial population down more than 40%, 6,000 individuals, 3,000 black, 1,500 white, 1,500 Hispanic. So you can look at that two ways. One is, wow, why, what's the overall mix? Why are so many diverse individuals in custody to begin with? And I think that's a fair question that goes beyond the judiciary and beyond risk assessment tools. And you need to examine all the actors. Judges are responding to cases that are brought into the system. And I think all of us need to together discuss the impact of race on the decision-making process at different stages. But then if you look at it in terms of the effect of judges' decisions that are now aided by risk assessment tools, the large majority of the advances have been for people of color. So we need to keep looking at it. But there is, I would suggest, under that second lens, some good news to examine as well.
Okay, we can have one more. That's right there. Yeah.
So I just joined Dubois from an immigration clinic, and I spent 3 years litigating FOIA requests on the Department of Homeland Security risk assessment system. We're about to publish those results. They basically show that the risk assessment tool was manipulated in 2016 to take on all of your conversations and the particular concerns about how these risk tools are used and how they're constructed, what you think the role of transparency and that methodology is to catch some of these things and provide light on what the unintended consequences might be or their effects on outcomes.
Okay, so the question is the transparency of the risk assessment tool, and I think this, in a context where some of the companies that develop these tools consider that the mechanics of it are proprietary. Who wants to take this? Okay,
Well, and Stuart can add to this as well, because New Jersey, Arizona, Kentucky, several other jurisdictions use a risk assessment tool called the PSA that was developed by the Arnold Foundation, that one of, I think, the key virtues is its transparency. They're quite open about how they've identified the factors that are considered. They're open to continual reevaluation. There are, as Dean Levy said, there are some proprietary entities out there that have developed risk assessment tools, and it's kind of a black box. And I would be very wary as a court leader of wanting to adopt that kind of system. I think that's kind of antithetical to the way courts should work.
so
I want to add to what Scott said, and I agree. The Arnold Foundation tool that we use has 9 factors. Go on our website. They're all listed there. Every defendant in each of the tens of thousands of cases gets a PSA, a report that identifies the factors and identifies how they scored on them. It was important to us, and we've maintained the transparency that the Arnold Foundation has encouraged.
So we have a hard stop at 1:30, which is unfortunate, but what a wonderful panel. Thank you so much for being here with us.